You may proceed.
Good morning. My name is Dylan Graham. I represent the appellant, Stone and Properties. This is an appeal from a final judgment following a non-jury trial on a foreclosure case.
Counsel, would you like to reserve some time for rebuttal?
2 minutes, please. Thank you.
Good morning.
The problem is that the plaintiff failed to allege and prove that it had standing to bring...
Counsel, at the time of the foreclosure, were the original promissory note mortgage turned over?
Yes.
Then what's the issue?
The promissory notes are payable to Mercantile Bank, a non-party.
There was a merger. Yes,
there was a merger.
To the entity that actually substituted itself as a party here and turned over the original promissory note and the original mortgage, which weren't canceled. Correct?
No.
They're not?
No. The merger occurred in July of 2007, and the promissory notes were issued.
Mercantile merged with Carolina Bank, which merged into TD Bank, which is currently the appellee before it.
Right. The merger the last merger is really not relevant to the issues before the court. The problem is that the merger from Mercantile Bank, who the notes were made payable to, preceded the issuance of the notes to Mercantile Bank. So when you look at the allegations of the complaint, it says...
the promissory notes say on their face, I believe, Mercantile Bank and a division of Carolina. Do they not?
Yes, they do. But when Mr. Lozano, the only witness that testified for the plaintiff, TD Bank at trial, he said that the promissory notes were issued to Mercantile Bank, not Carolina First Bank. And under Florida law,
the promissory note signed by your client, everything says Mercantile Bank, division of Carolina First. Okay. Your client got the money from these people. These things were all signed. This was a merger with this bank, with TD Bank, who showed up with the original documents. These are negotiable instruments, and turned them over to the court. That's all that's necessary.
A division of California Bank does not make Carolina Bank the payee of these notes. There's no entity recognized in Florida as a division.
Counsel, when I talk, you don't talk. At the foreclosure, an entity, it could have been grandma's whatever, had the original promissory note and mortgage in its hand. The original. That entity was the entity that was named as the party at the time in this lawsuit. And they turned over the original. Is there anything more that you need to have in your hand at the time of the foreclosure than the original?
Yes, you have to be a holder, and the holder, the party that these notes were made payable to is Mercantile Bank,
wasn't the holder the person with these things in their hand at the time of the foreclosure? Were they not the owner? Did they not allege they were the owner? Were they not the owner?
A holder on the Uniform Commercial Code.
Were they not the owner of these documents?
They have to prove that they're the holder.
Don't they say owner or holder?
They haven't proved either one.
Counsel, what is your very best case that you have?
The argument is that these notes were made payable.
Counsel, what is your best case that says that an entity that hands over the original a negotiable instrument at the time of foreclosure does not have the authority to have those foreclosed?
DAC versus Jean-Jacques. It's right on point. In the Jean-Jacques case, the notes were made payable to Fremont Loan, and the person trying to foreclose on them is U.S. Bank National. It's the same situation here. A division, Mercantile Bank, a division of Carolina First Bank, is a non sequitur. It does not exist under Florida law. Because Mercantile, in the complaint, it is alleged that Mercantile Bank is a Florida corporation. It's not alleged that it's a DBA of Carolina First Bank or that it's a trade name of Carolina First Bank. It's a non-event saying that Mercantile Bank is a division of Carolina First Bank. The mergers proceeded the issuance of the notes. Carolina Bank is not a party to these notes. They're just not under Florida law.
Your whole argument is no standing, so there could have been no foreclosure. Is that the entirety of your argument?
Correct, and the evidence that was, you have to stay within the allegations of the complaint. The complaint was not that Carolina First Bank owned and held the notes and mortgages. It says that Mercantile Bank, a Florida corporation, loaned the money to my clients, and that Mercantile Bank was the named party on these notes, not Carolina First Bank.
Counsel, what is your position? Who is the entity that you believe would have standing to foreclose on the property?
Mercantile Bank. That's what's alleged in the complaint. And even when their witness was asked at trial, he said that these notes were payable to Mercantile Bank.
How exactly in your answer you say that Mercantile Bank was not a corporate entity in existence at the time it entered into a transaction? So you're saying they're the ones who have the ability to foreclose, but then at the same time you're saying they were not a proper corporation in existence. So are you suggesting...
That's how the proof came out at trial.
So your position is it's Mercantile Bank, even though you're alleging in your answer that they're not a corporate entity.
That was an affirmative defense. Plaintiff is the one with the burden of proof. They have to allege and prove their case, irrespective of the answer. We denied that Carolina First Bank owned and held the notes and mortgages, and we denied that they have standing. That's all we had to do. Then they had to prove that Carolina First Bank had standing by the testimony by the allegations of the complaint and by the testimony of their own witness. Carolina First Bank was not the named party on these notes. And saying that the fact that the note said Mercantile Bank, a division of Carolina First Bank, has no significance legally. Under Florida law, it could have been Mercantile Bank DBA. It could have been Carolina First Bank DBA Mercantile Bank, or they could have proved that Mercantile Bank was a trade name of Carolina First Bank. They didn't do that. When I asked their only witness at trial if he said in direct examination that Mercantile Bank was a trade name of Carolina First Bank, I objected to it as being outside the scope of the pleading, because they said that Mercantile Bank was a Florida corporation, an entity, a separate person unto itself. And then on cross-examination, when I asked him about a trade name, I said, how do you know that it's a trade name? He was only involved in collections. He said that he was not involved in the legal administration of the business. And I kept pressing him, how do you know it's a trade name? And he said, well, it's in the newspaper. I said, do you see it in the newspaper? No. I kept pressing him, and he said, well, it's public record. And I said, have you seen it in the public record? He said, no.
And okay, so let me ask you the appellate question. Say we unwind all this. Has your client been paying this mortgage all along?
That's not the...
But you have to show harmful error, and the thing is, a mortgage has been foreclosed. And so now the promissory note in the mortgage has been nullified. It's nullified. So now we go all the way back. We say, reinstate the mortgage, reinstate the note. Let's find out who really owned this note mortgage. It was Carolina Bank. Carolina Bank's the proper party. We come all the way forward here, and what's the end result? Your client hasn't been paying a note mortgage for a very long time, and it gets foreclosed. Boom, that same exact note mortgage that has already been canceled gets canceled again and handed into that judge. So where is the harmful error that we should be reversing all of this for, to go back to do a do-over for? We only do reversible error.
Your Honor, the harm is to the justice system. A plaintiff has a burden of proof. If you don't prove your case, then you can't win.
But
it's
the
like
error here,
in the O.J. Simpson case.
Counsel, please do not. Please don't go there. That's not appropriate. You have to demonstrate reversible, harmful error. Not, I know that we want to talk about, Scout and all these things about, To Kill a Mockingbird. But the question is, each case has to demonstrate reversible, harmful error. And unwinding all of this just to go back and trace where everybody's the result will be that same note and mortgage will be turned in.
It's not. They had a chance to prove their case. They didn't prove it. The harmful error is that somebody that doesn't own, that did not prove standing, they did not prove that they own and hold the note and mortgage, won the case.
Your real claim, though, is the one which is oftentimes the claim that's made. You have to reestablish a note and mortgage, which is you want to be certain when there's not a physical document, that will never come back and bite you again. But here, the original note and mortgage were canceled. So that can't get you where you need to go in this case. That's the problem. Counsel, I've let you use all your time, but we'll still give you 1 minute for rebuttal.
Thank you.
Good morning, Your Honor. Alex Alves on behalf of the plaintiff in this case, TD.
So somebody who doesn't own this note and mortgage actually foreclosed it? Is that what happened here?
No, Your Honor, that's not at all what happened here.
Is note and mortgage ever going to come back to bite these people again? Ever?
The note and mortgage is never going to come back to bite the defendant in this case.
Were the originals handed over and canceled?
Both original notes, the original mortgages, all the original documentation was submitted to the court at the time of the trial, and were canceled by the court and are no longer in existence. And as I think you understand the argument, I'll just go through it one time for you. We had
the word that springs to mind in many foreclosures is sloppy.
Yes. There's the pleadings. There was a mistake in the pleading that kind of brought this whole issue into existence. There was a pleading allegation in paragraph 16 of the complaint that indicated that Mercantile Bank of Florida Corporation initiated a loan, which in fact was not originated by Mercantile Bank of Florida Corp. That corporation at that time had already ceased to exist independently and had, by virtue of a merger, become a part of Carolina First Bank. The allegation should have properly read that Carolina First Bank was the entity that originated the note in question. That is what was proven at trial. The original note, as the court stated earlier, was the payee was Mercantile Bank, a division of Carolina First Bank. So when Carolina First Bank merged with TD Bank, and TD Bank was before the court at trial with the original note and the original mortgage, the court properly found that TD Bank had standing to foreclose.
And you submitted at trial the articles of merger, a certified copy of the articles of merger for Carolina and TD Bank.
Yes. The plaintiff, at the time of trial, submitted a certified copy of the articles of merger. There was testimony from the plaintiff's only witness regarding the fact of the merger that was evidenced by the articles of merger. The defendant in the case went a step further and introduced the articles of merger between Mercantile Bank and Carolina First Bank. There was testimony as well that the witness was aware as an officer of TD Bank and an officer of Carolina First prior to that of the fact of the merger between Mercantile and Carolina First Bank. What we have, Your Honor, is an action for foreclosure on two notes. There was an error in the pleading as to one of the notes, but at the trial it was proven that there were two notes, two valid obligations evidenced by two writings, both of which were in favor of Mercantile Bank, a division of Carolina First Bank, both of which were secured by mortgages on property owned by the defendant. The original loan documents were admitted into evidence through a senior vice president of the bank who testified as to his involvement with these particular loans. The court found that the testimony of the only witness called at trial was credible. The court accepted the notes and mortgages, canceled the same, and entered a final judgment in favor of the plaintiff, TD Bank. At this time, Your Honor, we would ask that the court affirm that final judgment of foreclosure in favor of TD Bank.
Thank you.
Counsel, 1 more minute.
Your Honor, if I'm not mistaken, counsel has just confessed error. There's not a single case in the state of Florida that says where the plaintiff fails to prove that they have standing, that the appellee must demonstrate irreparable harm.
He said that they produced the original note.
I'm sorry, there's an echo.
He said that they produced the original note at trial.
Correct.
And that note established TD Bank's standing. That's what he said.
Well, that's wrong. The person with standing is a holder of the note. You can be a holder of the note if the note is made payable to you.
If they produce the note, they're holding the note at least, right?
No.
And then they're showing that these prior entities were appropriations that were acquired.
In street language, they're holding the note, but in law, a holder of a note under the Uniform Commercial Code means something completely different. A holder of a note is somebody that has bare paper, paid to the order of blank, or it has to be payable to an identifiable person, and that identifiable person has to be in possession of the note. This note was made payable to Mercantile Bank. They admit that the allegations of the complaint say that the note was made payable to Mercantile Bank. The note was not endorsed to anyone. The note was not assigned to anyone. So the Florida law is replete that they are not a holder of the note.
Thank you, Counsel.
Thank you to both of you.